Good afternoon. Welcome on in to this episode of From Day One. We'll start in the courtroom courtesy of our good friend Law Talk with Mike. We also have the conclusion of the Solve-Sit accountant.
Well, I first want to point out that settlement information is supposed to be barred under Michigan Federal Rule of Evidence number 408.
Okay, you can educate me on the law at some other time. I know it better than you. Go ahead. So I could hear you, but I can't see you. And I'm trying.
No worries.
Just a second. What did I do? Join the meeting? What? Huh?
It says leaves.
I don't want to leave.
Well then, are you sure you?
Did I do something? All right.
Hit cancel?
All right. We just launched the shuttle. It's on its way.
Yeah.
And hopefully it has a safe landing. Do with you. As far as other things, he's talked about orthodontics, why he doesn't necessarily agree to it, talked about the dosage increase, indicating that using drugs, that mother uses secularistic beliefs to deny God in the lives of the children, using drugs to replace God's divine interactions, such and such. Driving so that too young and ADHD evaluation.
Yada, yada, yada.
I don't know why. I can't imagine why it's against it. Do you want to add anything? It's just a Fadvarka type situation that it's pretty clear the parties do not get along, and I'm going to have to do something. But I'm going to ask Mr. Quano for his brief response. Anything you wish to add, Miss? Because I know what's going on.
I appreciate it, Your Honor. I guess I would just tell for the record that since the filing of this motion, and as this court just elucidated, I think it was his second response, which referred to why he disagrees with orthodontics. He's now unilaterally. Oh,
Oops.
can you not hear me?
Don't interrupt.
Oh,
No,
I'm sorry.
no, it's not you. I just somehow lost my connection here. So I could hear you, but I can't see you. And I'm trying.
No worries.
Just a
Get better,
second.
Moose.
What did I do? Join the meeting? What? Huh?
It says leaves.
I don't want to
Yeah.
leave.
Well then. are you
That's why I
sure?
like him already.
Did I do something? All right.
Hit cancel?
All right. We just launched the shuttle. It's on its way.
Yeah.
And hopefully it has a safe landing. All right. What is it you want to add? Sorry, I just lost you for a minute.
No worries. I guess just for this court's, knowledge and context, per the court's recent recitation of, I believe it was the second response about why he doesn't agree with orthodontics. We just found out yesterday that he's unilaterally scheduled some appointments with the orthodontist without confirmation with my client. It just goes to the perfect example of why these parties simply cannot get along. They are just not meeting in the,
This attorney is excellent, but I mean, come on, the judge can't take it. We're now in here griping about unauthorized orthodontic appointments. It's too much.
we're just not we're not nearly on the same page whatsoever. And the last response that this court seems not to have received is 17 pages long of the similar types of recitations that he makes in the other ones, which it just, again, support the fact that these parties are not able to come to a decision. And I guess I'll just once again reiterate that they have tried mediation, and it is an abysmal failure and an opportunity for Mr. Kawano to abuse Ms. Hodgkinson.
All right, anything you want to briefly add, Mr. Quano?
Well, I first want to point out that settlement information is supposed to be
Emphasis on briefly.
barred under Michigan Federal Rule of Evidence number 408.
Okay, you can educate me on the law at some other time. I know it better than you. Go ahead.
I'm sure you do. Okay, so we're gonna admit this.
Admit what? All I'm asking is whether or not the two of you can get along. There does appear to be Vadvarka to have an evidentiary hearing. I'm not gonna change the legal custody here today. I just have to have an evidentiary hearing. And it pretty much, I mean, your answer says you don't get along on anything.
No, that's not true, Your Honor.
Yes, it is.
Well, we've agreed on a great number of things, including homeschooling, most recently, the last couple of weeks of vaccinations, which a lot of parents don't agree on. There's a whole long list of things we've agreed on, and these few items, I'm waiting on some responses from her. And she mischaracterizes how I'm trying to work with her. For example, saying that unilaterally scheduled appointments, I did not. I've been very clear with the orthodontist. I was penciling things in so we didn't lose time, so that when they would talk to me, we would still have options. That's not unilaterally deciding on things. That's me trying to work with her. Every time I try to work with her.
Well, maybe it's her that won't work with you, and we'll figure that out at that legal custody.
What does that mean, Your Honor?
That means that the two of you don't work together, and as a result, I have to have an evidentiary hearing whether or not legal custody should remain with both of you. Maybe it should go to her, maybe it should go to you.
Is that an option, sir?
What?
Your Honor, is that an option?
What do you mean? Legal custody, I have to determine who it would go with.
Realize that?
Well, I thought you knew the law. You were quoting it to me earlier.
Sorry.
So I don't think there's any way that I get around the fact that, I mean, you now tell me that she doesn't work with you. And so there is no way that I'm gonna be involved with this case for year after year, making the decisions, because next thing I know, Ms. Wolfram is gonna file a motion to say he needs to have his dosage increased. He won't agree to it. So
Yep.
I gotta make the decision. And
Preach it.
that's what it comes down to. And then the next thing it's gonna be, you don't agree to have them start driver's training, so that's a decision. You don't agree, she does, so I'm gonna have to decide it. And I'm gonna figure out what is appropriate or not. The two of you do not work together, no matter what you say, or at least on a majority of the stuff. And as a result, I'm gonna have an evidentiary hearing regarding legal custody, whether it should be changed, whether it should be in one person or another.
Your Honor, can I ask about the motion they submitted? Said that, again, I don't know the law that well, but I'm gonna ask, they said that it would be tried on preponderance of the evidence. But it doesn't look like the law says that it should be on clear and convincing evidence, which is a slightly.
We'll find that at the time that it happens. Miss Wolfram can say it could be based on, anything she wants. We'll find that at the time of the hearing.
Okay, I have requested relief that they'll be got in, but,
What?
well, one of my reliefs is that the children are struggling in math, and she's refused to send their homework with them, and I was just asking if that could be in order that they be send their,
How often do the kids see you?
well, you ordered that it'd be every week.
For how long?
For an hour and a half, you have time to work on things, eat dinner.
If she thinks it might be appropriate, fine. I'm not gonna get involved in micromanaging at this point. If the kids have homework and you wanna send it, fine. If not, fine. You should spend some time with your kids. That's where we're at. I'm gonna set an evidentiary hearing regarding legal custody. It will not be real soon, so if you need to have the dosage or something dealt with, you're gonna have to file a hearing here, and I don't know if I'll get you in any faster for that. All right, that's just, I don't have that much time out there. I'm scheduling out into February, I think, but I will get in for an evidentiary hearing regarding legal custody. Good luck, everybody. That's the ruling of the court.
Thank you.
Thank you. We'll be in contact to set up that hearing.
Do I need to do a separate order just granting the evidentiary hearing, or will the court just issue the notice?
We'll issue an order that'll, we just do a notice of hearing. There
Okay.
will be things on there that you have to follow, you know, I know you know what they are, and it's like, trial brief and exchange and all that kind of stuff. And that's what it will be. Follow the order. Good luck.
Perfect, thank you.
Thank you.
You're gonna probably try me in absentia, and you're not gonna prove anything.
The one that last was in 2013, but the defendant got a
Okay, I did this yesterday, I just went with the bit I had, which was good. But then, so I'm replaying that part because it wasn't long. But the rest of the hearing gets worse. It's so good.
around good enough to beat this woman, steal her car, and then steal something else from her. And then after that, Your Honor, made threats to kill her. So he was able to be functioning enough to do all that, Your Honor. So
Oh, there we go. Intimate shave. Apparently, April's doing the whole intimate shave trial. That's been fantastic. Go over there and check it out after this stream.
now all of a sudden his health done turned for the worse. Now he wants to get out. Your Honor, he's going to assault this woman.
Your Honor,
Information that the-
please, Your Honor, please, may I speak? Please.
Mr. Jones, I'm gonna let you talk to Mr. Ward for a second. He is your attorney, so Mr. Ward.
Mr. Jones, I don't think you should speak right now. Do not.
Because he's lying though, Mr. Ward, and I would like to tell him, and my family already talked to the girl, talking to her, and
Your Honor, I'm asking that his bond get raised to $100,000 cash.
Mr. Jones, you need to stop talking.
Yes,
Your Honor,
ma'am.
I'm asking that his bond get raised to $100,000 cash. He just admitted to having other people contact the victim, which
No,
means
that's a
complete
lie.
witness
No, I
tampering.
didn't. She went to them.
Mr. Jones,
to my
please
mama
stop
and
talking.
talked
Mr.
to
Jones.
them. He just lied. He just slandered me, Your Honor. The prosecutor just slandered me because my mother them will verify and you can listen to the court to the phone messages here. I have not talked to her, and my family have not talked to her. He just slandered me, telling a lie that I have not. Nobody have talked to her but through my mama. She talked to my mama because of her boys. And when the boys want to talk to me or
Mr. Jones, I really think you
Mr.
should stop
Jones, you're
talking.
not doing yourself any favors right now. What you just
Well,
opened
you
the door
said it.
for is additional investigation into witness intimidation.
I
So
haven't
I'm
been-
not going to
okay.
change your bond right now. Mr. Ward,
Uh-huh.
if you get additional information as to housing where he could be home confined with a GPS to a location that I know that could be monitored by the Judicial Service Group or Community Corrections, we can't monitor him without some place for home confinement. And so I'm unwilling to make any bond modifications at this time, but I'll allow you to bring that back up. Looking at the form from the Community Corrections also noted he had multiple failures to appear in the past, that there were multiple threats to kill the victim, and in front of the police also threats to beat the victim for what he said was lying to the police. I'm using that all into consideration under 6106 to maintain the bond right now. I'll leave both parties to their presumed investigation. What date, Mr. Ward, do you want to put this out so you can interview the witness?
Maybe.
We're not
30 days,
done.
Your Honor.
Do the 16th?
My
30th,
mother
Your
them
Honor.
can be up there to the my mother them
Your Honor.
can be up there to see both of them, and I can call my mama to
Mr. Jones, we're gonna let you
back
talk
my
to your
room.
attorney, Mr. Ward. You're walking into
He's not
something you
doing
don't want to
anything.
step into, sir.
He's not doing anything. I'm a paralegal. I can talk for myself.
Oh, sweet Jesus.
I would rather do my own bidding for myself. I am a paralegal. By law, I'm allowed to represent myself, because if you listen to what the prosecutor said, he going way back. I have an AC joint separation in my right shoulder, and I have no cartilage in my right knee. And he talking about I can do this, that, and the other. I was upset and I was drunk that Friday to help my
Mr.
sister.
Jones,
Jones, we're done.
please stop talking.
We're
Please keep
done.
talking. Please.
Correctional officer, whoever is working
Please.
I'm sorry, I can't see who you are. Mr. Jones is done for the day
Wow.
before he admits to his entire offense. He's making the prosecution's case for him. That's not happening today.
Boy, I'm just getting railroaded here.
For production are separate. I don't need them in the deposition. I just need her.
Okay, this happened a couple days ago. She never comes on. You don't get to see the Karen accountant, but here she is with her spreadsheets.
So ma'am, we are gonna, the latest I'm gonna set this is November 2nd. So.
Why?
Be,
Why is that the date? I don't understand the urgency. I don't have my information ready. They don't have their information ready. It's premature. I can't answer their questions without getting my information prepared. And if you've received my other motion, you'll understand I've had 32 court dates in 20 weeks and 200 line items. All I need is 80 hours.
Aaron Winkles has some good facial expressions for this one.
To prepare it, but I can't because I'm in court every week doing something else other than discovery.